Thank you, Chairperson. Good morning to yourself, the members and everybody else that's present this morning. Chairperson, in preparing for the meeting, I thought it might be wise to share my own notes, and this has now been done in the form of an aid memoir that has been circulated to members and hopefully can serve as a reference guide as members proceed with deliberations today. The purpose, Chair, is not to give legal advice on the veracity of the charges or to deal with any evidence related to the charges itself. That is something that members will deal with themselves in reaching their conclusions. I've also, Chair, in this document, tried to highlight some issues not necessarily related to the substance of the charges themselves that Adv Mkhwebane had raised, and that I think it's important that the committee considers for purposes of drafting the report. Chair, by way of background, I'm not going to go into too much detail because, as you said, members will be quite familiar. But in terms of the rules, the purpose of this inquiry was to establish the veracity of the charges and to report to the NA, and to ensure that the inquiry that is conducted by this committee is conducted in a manner that is reasonable, procedurally fair, and within a reasonable time frame. And of course, importantly, to afford the holder of the public office the right to be heard in his or her own defense and to be assisted by a legal practitioner. The committee, as it knows, must now report its findings and recommendations, including the reasons for that, to the NA for consideration and debate. And that debate will be scheduled with due urgency given the program of the NA. And of course, as we know, there needs to be, in the event that this committee recommends a removal, that would need to be supported by a two-thirds majority. Chair, the motion that was submitted on 21 February 2020 consists of 4 main charges and various sub-charges. So it can get a little bit confusing, but we have prepared questions to assist members. So the first one, charge 1, is misconduct in the South African Reserve Bank matter. And that one consists of 9 sub-charges. It has to do with the PPs.
Are you able to show that?
To show the report?
That's all.
Oh, people can put up the aid memoir, that's fine. She has no need for a Chair. But it has been circulated to members. The first charge, so I'm not reading from the motion itself. The first charge is the one of misconduct, and that has to do with the South African Reserve Bank matter, as I indicated, and the investigation and the litigation proceedings relating to the review of that report. And Chair, members will know that we've interchangeably referred to that report as the SEX report, the lifeboat matter, the SARB report. So you might see in evidence, we would have seen it in the summation, that it gets referred to differently, but it all has to do with the same matter. Charge 2 was the Theatre Dairy matter, and that had 5 sub-charges, and that had to do with report 31 of 2017. Charge 3 was a charge of incompetence, and it alleges incompetence in relation to both the theatre and SARB matters. So whereas charge 1 and charge 2 were limited to misconduct in respect of those 2 matters, charge 3 now raises incompetence in respect of the investigation, the report, and the litigation in those matters. In the SARB matter, there were 9 sub-charges, and in the theatre matter, a further 6 sub-charges. This charge 3, Chair, also deals with the Financial Sector Conduct Authority matter, which is also interchangeably referred to as the Chile matter, and it has 2 sub-charges therein. So this one is dealt with a little bit differently, and members will see that when we go through the questions later. Charge 4 was a broad charge, Chair. It was misconduct and or incompetence. So it was a mixed charge, and it contained 2 sub-charges, paragraph 10 and paragraph 11. The first sub-charge in paragraph 10 is what members would know as the HR issue, which I think the PP has also referred to as the HR issue. And that relates to the alleged intimidation, harassment, and or victimization either directly or indirectly through the CEO, Mr. Mshlangu, of staff. And in particular, then there were 7 staff members that were named. So Pikana, Mr. Samuels, Mr. Madiba, for example. And that's all listed from 10.1 to 10.7. So there would need to be findings made in respect of each of those persons, and then the question generally as to whether there was victimization, harassment or intimidation of staff, and if so, whether that was by the people or via Mr. Mshlangu. The second subcharge under number 4 relates to misconduct and or incompetence more generally. And briefly, the first part is management of internal capacity and resources in the PPSA, the prevention of frivolous and wasteful and unauthorized expenditure and legal costs. And members will recall there was quite a debate in the committee as what the meaning of legal cost is and whether it included legal fees or if it was limited to costs awarded by a court. But obviously that's already included in the summation. Part 3, failure to conduct investigations independently and impartially. And then part 4, deliberately avoiding making findings against or directing legal action against certain public officials, while on the other hand, deliberately reaching conclusions of unlawful conduct and imposing far-reaching legal action in respect of other officials. In support of charge 4, Chair, all of the evidence in the theatre and SARB matters were included as part of the motion. So everything that would have come under charge 1 and charge 2, all of the, in the main, all of the court records. In addition, in support of charge 4, Honourable Mazzoni also submitted evidence in respect of the CR17 matter and the SARS unit matter, which also has interchangeably been referred to as the Road unit matter. And then also in the GEMS matter. That matter revolved around a complaint by a member of the public against the government employee medical scheme and litigation pursuant thereto. There was no report issued in the GEMS matter. Chair, as we know, the Speaker ruled that the motion was compliant with the NA rules, and thereafter establishing independent panel comprised of Justice Mkhwebane, Advocate Mkhwebane, and Advocate Deval, Advocate Bar. Their role, Chair, was to determine whether there was prima facie evidence that Advocate Mkhwebane had committed misconduct and or is incompetent as alleged in the motion. The IP submitted a detailed report which forms part of the record, and they found that there was prima facie evidence of incompetence and misconduct in respect of both SARB and theatre matters as contained in charge 1 and 2, incompetence in respect of SARB, theatre, and the Financial Sector Conduct Authority matter in charge 3, incompetence in respect of CR17 SARS unit and the GEMS matter as contained in charge 4, and then misconduct in respect of the Financial Sector Conduct Authority, CR17, theatre, dairy, and the SARS unit matter again in charge 4. However, Chair, the IP did not make findings of prima facie evidence in respect of every single subcharge. So as I've indicated, each charge had various subcharges. In particular, Chair, it's important to note that they found there was no prima facie evidence in support of the so-called HR matters in paragraph 10 of charge 4. Their findings are all summarized in Annexure A of the independent panel report. So if members want to quickly reference where they found that there was prima facie conduct, that can easily be found in Annexure A. That report served before the NA Chair, and as we know, the NA proceeded to refer that report to this committee, or rather the motion, then the report. Chair, the committee, you'll recall, adopted a terms of reference, and we set out, amongst other things, the background to the task, the format of proceedings, including the way in which evidence will be received, matters relating to public participation, transparency of proceedings, and the resources that will be available. There was emphasis on the fact that it's a constitutional process, that it's inquisitorial in nature. And we also provided for the appointment of external evidence leaders to assist the committee by presenting evidence and putting questions to Adv Mkhwebane and other witnesses. The purpose of using evidence leaders, Chair, was to empower members and the committee to perform their functions and the evidence leaders do not play a prosecutorial role in this matter. The TRR further provided that Adv Mkhwebane's Audi rights would be cemented by giving her the right to make opening and closing arguments, to cross-examine witnesses, and to raise any matter related to the process, subject to the reasonable time frames as imposed by the chair. Chairperson, the PP has indeed been provided with an opportunity to make an opening argument, which was done by Adv Mkhwebane on day one. She was invited to do a closing argument either orally or in writing, but as members would be aware from the correspondence that has been tabled, she's indicated that by her attorneys that counsel has not been briefed on the merits of the matter, and therefore these deadlines have not been met and those requests were not responded to. In addition, the terms of reference also provided that Adv Mkhwebane will be afforded the right to comment on the committee's draft report before it's adopted. So once the draft report is tabled, Chair, the report will need to be adopted by the committee as a draft report, then sent to the PP for comments, after which the committee can consider those further comments before it adopts a final report for tabling in the evening. The scope of the inquiry, Chair, this has been a contentious issue rather, in that the IP did not find, as I indicated, that there was prima facie evidence in respect of every single subcharge. But what members must bear in mind is that the IP, and I've already advised on this, Chair, was not entitled to hold oral hearings, and its assessment was limited to the written and reported information that was placed before it. And it could not and did not conduct an independent investigation that could lead to a determinative conclusion on whether or not there has been misconduct or incompetence. The IP therefore did not have the power and could not conclude that only some charges should be investigated for determination by the committee, or that some charges should be excluded from consideration. If there were to have been such an instruction, it ought to have come from the National Assembly at the time when it referred the motion, but the Assembly referred the motion in its entirety to this committee. And in fact, Chair, the independent panel noted in its report that it stresses from the outside that it's not tasked to conduct a Section 194 inquiry for the removal from office of the people. That task is for this committee. Here, the committee is therefore duty bound to consider all of the charges and to make findings in respect of all of the charges as contained in the motion, and not just the charges where the independent panel found that there was prima facie evidence. I have listed it there for easy reference for members, but this is basically what is contained in Annex A of the report. Chair, I'm going to move on to the constitutional provisions with public protector, just to give members a quick reminder. As we know, Section 181 establishes the public protector as a state institution strengthening constitutional democracy in the Republic. They are colloquially referred to as Chapter 9 institutions, and these institutions are governed by the following important constitutional principles. One, they are independent and subject only to the Constitution and the law. They must be impartial and must exercise their powers and perform their functions without fear, favor, or prejudice. Other organs of state, through legislative and other measures, must assist and protect these institutions to ensure the independence, impartiality, dignity, and effectiveness of these institutions. And importantly, no person or organ of state may interfere with the functioning of these institutions. These institutions report to the NA on their activities and the performance of their functions. And of course, we know that the Office of the Public Protector also reports to the Justice Portfolio Committee in terms of the oversight responsibility. The functions of the Public Protector in particular are captured in Section 182 of the Constitution. The Public Protector has the power to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged and suspected to be improper or to result in any impropriety or prejudice, to report on that conduct and to take appropriate remedial action. Chairperson, as members will know, that remedial action that the Public Protector may take is now binding following a ruling from the Constitutional Court in that respect. The public protector has additional powers and functions as prescribed by legislation. The public protector may not investigate court decisions. The public protector must be accessible to all persons and communities, and any report issued by the committee must be open to the public unless exceptional circumstances to be determined in terms of national legislation require that the report be kept confidential. Members are aware that the term is a fixed term of office of 7 years, and currently this term comes to an end in mid-October. Section 193 of the Constitution deals with the appointment of office bearers, and the public protector in particular must be a South African citizen, and importantly must be a fit and proper person to hold that particular office. So the removal deals with this issue of whether the person is fit and proper, and the person who has committed misconduct and has otherwise proven to be incompetent, then would follow that they are not fit and proper to hold office. Section 194 of the Constitution deals with removal, and it states that the public protector may only be removed on the ground of misconduct, incapacity, or incompetence. A finding to that effect by a committee of the National Assembly, and that will of course be this committee, and the adoption by the Assembly of the resolution calling for that person's removal from office. Members will recall that Advocate Mkhwebane did argue in his opening address that this committee is not that removal committee, but if I recall correctly, I think I had advised at the time. The Constitution did not define misconduct, incapacity, or incompetence. And in fact, that was one of the reasons that it was then necessary for the NA to issue the removal rules. The removal rules define incompetence and misconduct. Misconduct is defined as the intentional or gross negligent failure to meet the standard of behavior or conduct expected of a holder of public office. And Chair, this is important because whilst the constitutional definition merely referred to misconduct, the rules have taken it further and said it must be gross misconduct, as it were. So the threshold in terms of the rules for removal is in fact slightly higher. It will therefore be necessary for members when establishing whether there is misconduct to ask these important questions. What was the standard of conduct or behavior expected of a person in the position of the public protector? Did Advocate Mkhwebane meet that standard? And if not, was her failure intentional or grossly negligent? In other words, it's possible not to meet a standard, but there can still be a finding that the failure wasn't intentional or grossly negligent as required by the law. Chairperson, the issue of intention is obviously subjective, and it's concerned with what that individual in question would have personally understood would happen in circumstances. And in law, intention can take one of three forms. The first is what we refer to as dolus directus, and this is where the individual deliberately aims at causing the consequence in question. So the example cited here is when X fires a gun at Y with the intention of a bullet harming Y. So in other words, I now know that the result of this will be that the person will be injured. When the individual aims at causing a particular consequence, but knows that another consequence would be inevitable. For example, X fires a gun at a cardboard cutout with the intention of putting a bullet hole through the cutout, but they know that somebody is standing behind the cutout, and that person is obviously then going to be injured. And that would be called dolus indirectus. And the third type of intention is where the individual aims at causing a particular consequence, foresees the possibility that another consequence could result, but reconciles himself to that possibility and proceeds anyway. So in layman's term, the person takes the risk, as it were. So using the same example, X fires a gun at a metal pole with the aim of hitting the pole. He foresees the possibility that the bullet could ricochet and hit Y, but he reconciles himself to the possibility that Y could get shot and fires the bullet anyway. That's dolus eventualis. The test for negligence, Chair, is something that must be assessed objectively, not based on what a particular individual thought or understood, but based on what a reasonable person would have understood and done. The public protector would only have been negligent if a reasonable person in her position would have foreseen the possibility of certain consequences arising. The same person would have taken the reasonable steps to guard against the consequences, and the public protector has failed to take those steps. Again, the threshold being high. Gross negligence occurs where there is an entire failure to give consideration to the consequences of one's action. In other words, an attitude of reckless disregard of such consequences. In terms of incompetence, the inner rules do not provide an exhaustive definition of incompetence. The rules rather define incompetence as including a demonstrated and sustained lack of knowledge to carry out and ability or skill to perform his or her duties effectively and efficiently. Sustained or forced change is something that we need to be considered within the context. There's not a number that can be put to the meaning of the word sustain, other than to say it would have to have been obviously more than one incident. The fact that an action may have been incompetent, or even two actions may have amounted to incompetence, doesn't necessarily make the person incompetent, which is why the rules talk of a demonstrated and sustained lack. In respect of incompetence, again, the committee would have to consider what Adv Mkhwebane's duties were and whether she displayed a lack of knowledge to carry out those duties effectively and efficiently, and whether she displayed a lack of ability or skill to perform those duties effectively and efficiently. And was the lack of knowledge and ability and skill demonstrated and sustained? So we're not looking for one-off examples. The test and threshold for removal. The definitions of misconduct and incompetence in the rules must be understood purposefully. There are threshold requirements for determining whether a Chapter 9 office bearer who has constitutionally independence and fulfills the vital function of ensuring accountability in the public sphere should be removed from office. So people in these positions cannot be removed willy-nilly. The test and the threshold is high. It's a serious matter. Accordingly, to ensure the proper functioning and protection of Chapter 9 institutions, a high standard should be adopted by the committee. Incompetence or misconduct should not lightly be accepted as having been established. The committee is exercising the public power in that it's making a finding and recommendation to the NA on whether there are grounds justifying the removal of the PP, and therefore this exercise of power must be rational and not arbitrary. Rationality can be understood as a rational relationship between the measures adopted and a legitimate governmental purpose, the cause for an objective inquiry. So, Chair, whilst there's been criticism of the fact that the inquiry is political, members will recall that when I did, or perhaps they won't, but when I did my very first presentation to the committee, I indicated that as much as it's a constitutional process, it's also a political process. That is the nature of Parliament, that you are sitting in a multi-party committee. But unlike in a situation where a committee or members of Parliament are deciding on a policy matter, over here, members need to show that a decision that they've reached is a rational decision. It's not a matter of preference, whether a member feels the PP should be removed, whether the member has any personal feelings on that issue. The member must be able to have established, or the committee must have been able to establish on the facts report and on the evidence that it's considered that there are rational reasons that support a finding of misconduct or incompetence. Chair, the question is how does the member or the committee consider or make a rational finding? And the rationality entails a consideration on the one hand of the evidence that's been before the committee vis-a-vis the standards of conduct expected of public protector, because of course you need to measure what the evidence tells us against what a person in the position of the public protector ought to have done, a reasonable person in that position. And for that purpose, Chair, the committee will recall that two witnesses were called, and I'm not going to call them expert witnesses because the committee knows that there was some debate as to whether they were experts or not, but be that as it may, there were two witnesses that spoke about the roles and responsibilities and the protection that should be afforded to a person in the position of public protector. And that was Mr. Hassan Ibrahim and Ms. Zulu Sikoni, the Ombudsman of Zambia. Now, Mr. Ibrahim proposed 47 obligations that a public protector must comply with in the discharge of their office. And this was done with reference, members will recall from his testimony on the applicable legal framework, including the constitutional provisions, the PPA Act, the case law, and so on. And in terms of those 47 steps, and it's important that members apply this when considering the evidence, is that a person in the position of public protector must respect the supremacy of the Constitution and the rule of law. They must strengthen constitutional democracy, focus on ensuring the discharge of public functions that is accountable, responsive, and open, respect the separation of powers and the legitimate sphere of operation of each branch of government, and in so doing, respect the decisions of the executive, legislature, and judiciary, be independent and impartial, and perform functions without fear, favor, or prejudice, be dignified and effective, be dedicated and conscientious, discharge functions diligently and without delay, exercise only those powers that are conferred by law, not assume the powers or functions of any other public functionary, or encroach on its integrity, be accessible, I've lost my space, adhere to a high standard of professional ethics, ensure the efficient, economic, and effective use of resources, ensure that services are provided fairly and without bias, foster transparency, be accessible, cultivate good human resource management, and be capable of managing an office that comprises hundreds of personnel and numerous departments and units, exercise appropriate and effective control over the Deputy Public Protector and the staff of the PPSA, delegate powers to the Deputy Public Protector to exercise, be capable of undertaking and managing numerous investigations and of understanding and applying the Constitution and the laws that regulate the public administration and affairs of the state, maintain an office that is accessible to members of the public, discharge functions ethically and effectively, monitor the performance of the executive, which includes investigating alleged maladministration, abuse of power, discourtesy, undue delay, improper dishonest conduct, improper enrichment, and improper or unlawful prejudice. Work to ensure that the public administration carries out its tasks without corruption or prejudice. Be the last defense for the public against bureaucratic oppression, corruption, and malfeasance. Investigate complaints from members of the public in respect of state affairs or public administration, report on the conduct complained of, and take appropriate remedial action. Decline to investigate conduct that occurred more than 2 years prior to the complaint, unless there are special circumstances that distinguish the complaint, and that would be in terms of the act governing the people. Consider a range of options in addressing a complaint, including mediation and negotiation, advising the complainant regarding appropriate remedies, and reporting an offence for particular conduct to appropriate authorities. In determining appropriate legal action, not to order an organ of state to do something that is outside of its powers, to make clear rather than vague determinations, to be objectively fit and proper to render the constitutional functions of office, to be appropriately experienced in the law, the administration of justice, public administration, and or the legislature, be a person of stature and beyond reproach, be suitably qualified, be scrupulously honest and have absolute personal integrity, disclose all material facts and evidence, and behave with utmost good faith when litigating, not exploit loopholes or show disregard for the law or mislead in any way or make charges without supporting evidence, ensure that all statements of the law are accurate and not misconstrue the law, be a good constitutional citizen, be willing and capable of taking on sensitive investigations that might antagonize the powerful, observe the requirements of procedural fairness and confidentiality during investigations, and allow potentially affected persons a proper opportunity to make meaningful representations, conduct investigations with an open and inquiring mind and follow wherever the evidence leads, discover the truth and continue digging until the true picture emerges, not extend investigation beyond the affairs of the state into private parties, not expand an investigation without lawful justification, be cognizant of the serious consequences that can flow from an investigation, inspire confidence in the integrity and completeness of investigations, and account to the intent. So it is quite a mouthful, Chair, and perhaps useful for those members that are involved in the appointment of the new PP. Could perhaps serve as a reference guide for them. During cross-examination, Chair, Mr. Ibrahim's expertise and the relevance of his experience were called into question, and I mentioned this earlier. However, the principles established above, rather the principles were not established as incorrect or inapplicable. Mr. Ibrahim did, however, concede that a public protector has the power to limit or extend the scope of an investigation, provided that there are reasonable and justifiable grounds for doing so. And those questions would have been in response to the fact that part of the motion alleged that the PP narrowed the scope of investigations, for example, in the Theatre Dairy matter, or widened in others. Ms. Zulu-Sekoni's evidence, Chair, covered the principles and standards that an ombudsman should adhere to or uphold, because she obviously spoke more generally and not in relation to South Africa necessarily. And she also spoke at great length about the protections that an ombudsman should be afforded and observations in this regard. Chair, her evidence should be read together, especially with the Oliver Tambo Declaration and the Venice Principles, which she spoke to in some detail about. But some of the things that she said, Chair, was, and this has been extracted, Chair, from both the evidence in chief and the cross-examination. To determine whether public protector has committed misconduct or has shown incompetence, regard must be had for the office standards and duties, including notions of what it means to be fit and proper. A public protector who does not play by the rules could be subject to impeachment. The public protector should adhere to natural justice and procedural fairness. These principles do not just extend to the ombudsman, but when the ombudsman is investigating, but also extends to the relationship that the ombudsman would have with members of staff. The public protector's office should be the example of par excellence. We should ensure that we are leading by example for other institutions, of what she said. The public protector's office must exhibit the highest tenets of integrity, professionalism, transparency, accountability, the cause of justice, the rule of law, and the Constitution. The public protector must act in a manner that shows she's independent so that people perceive her independence. In this regard, it is a non-negotiable for a public protector, I should say, not to be independent and impartial. The public protector must take responsibility for every report her office issues. The public protector has a special responsibility to tell the truth to courts and to file affidavits through. The public protector's reports should be honest, and the evidence referred to in those reports should be complete. The reports should reflect an understanding of the law, and the public protector should have the legal acumen of a judge. A public protector should not do anything to give the impression to the public that she has colluded or behaved improperly with a member of the executive branch of government. While a public protector must have a high standard of ethics, transparency, and lawfulness, she's also a human being, and there may be lapses here and there, and that is the reason why the decision of an ombudsman can be subjected to judicial review. And this, Chair, goes again to what I mentioned earlier about incompetence, is that incompetence is not merely the making of a mistake once or twice, it's sustained and demonstrated. Where the public protector's decision is successfully taken on judicial review, it's the duty of the ombudsman to interrogate that judgment and ensure that they do not repeat the sort of errors that were caused in that particular report. Ms. Sekoni referred to this as a cleansing process and a quality control process. And she made it clear that she would not expect the public protector to repeat the same mistakes once that error had been established in the court. Furthermore, she testified that it was not good for an ombuds's reputation to have judgments coming out continuously on the same issue, especially on the same matter, the same error, the same mistake. A court holding an ombudsman's decision to have been wrong is a way of ensuring excellence in the work of the ombudsman. However, an ombudsman who is aware of the principles and ethics of their job will take note of what the court is saying and implement it in their work to ensure that the error does not happen again. The office of the ombudsman should be above reproach. The members will see it's very much similar to what Mr. Ibrahim had testified on. Then Ms. Zulusakoni also spent a lot of time emphasizing the protections that an ombudsman should be afforded, again with reference to the Venice Principles and the Oliver Tambo Declaration. Chair, I thought it's important that I take the committee through these so that you understand some of the challenges that a ombudsman or a person in the position of public protector would face, and also understand the protection that should be afforded to them. The principles all emphasize the need to protect the independence of the ombudsman. As the ombudsman investigates the very office which created it, funds it, and which is supposed to pay the salaries of the members of staff and the ombudsman themselves. So we know that as far as Chapter 9 institutions are independent, in the same regard, they also rely on government for their funding. To this extent, the OR Tambo Declaration states the independence and autonomy of these institutions must be guaranteed by the Constitution, and indeed our Constitution does do so. The Venice Principles refer to functional autonomy of the ombudsman, meaning that they should not be charged concerning their constitutional, legislative, or administrative functions. The ombudsman must be afforded the highest level of administrative and legal support to ensure that there is procedural fairness when any issue to deal with the institution is under the purview of any of the arms of government. She noted that the office of the ombudsman is inherently vulnerable because it investigates very powerful people. So, for example, the president and ministers in our case. The office of the ombudsman should be accountable to Parliament because through the systems of checks and balances of the separation of powers, one wants to ensure that the ombudsman reports to a body which it does not investigate. In South Africa, Chair, the PP does account to Parliament, but the PP may also investigate members of the executive who are also members of Parliament. The Venice Principles stress that the protection and promotion of human rights and fundamental freedoms should also be extended to the ombudsman, the deputies, and their staff. The judiciary protects the ombudsman in that where reports are tabled before the judiciary, they provide exclusive scrutiny and independent scrutiny. Procedural fairness requires that when a body is dealing with adverse court judgments against an ombudsman, there must be equal attention given by that body that is hearing the matter to favorable judgment. Prior to being suspended, an ombudsman should be made aware of the charges that are against them and be given a fair hearing. The legislature should assist an office who is accountable to them and accord the appropriate protections if they are available. Functional autonomy requires that investigations carried out, that where investigations are carried out by the PP, there should not be any interference in that investigation by any arm of government or from any person. And this also is codified in our Constitution. As stated in the OR Tambo Declaration, at minimum, the office of the ombudsman must be equated to that of a judge. And she spoke of her personal experience, saying that the classical model, and she just to remind members, because it was a long time ago, the classical model is where the remedial action or the recommendations of an ombudsman are not binding. So that's different to South Africa, where the Constitutional Court has found that it is binding. And Mr. Coney was of the view that that would have been a better and stronger model. Of course, that isn't the case for us. And if there has to be concern or issues raised in that regard, it won't be in connection necessarily with the charges, but it's important to consider it in relation to the fact that later on, she goes on to say that this is one of the reasons that there would have been an increase in litigation. Principle 11 of the Venice Principle states that the ombudsman shall be removed from office only according to an exhaustive list of clear and reasonable conditions established by law. And these essential criteria of incapacity and inability, misbehavior, or misconduct must be narrowly interpreted. And in fact, that's exactly what Parliament's done in Italy, because as I said, they made the threshold even higher. And as I've indicated to members, removal is not a matter to be taken lightly, and therefore members must ensure and be certain that the evidence supports removal if such a recommendation is to be made. Whether an incumbent who has a short amount of time in office left should be charged would depend on the gravity of the charges that have been placed against that particular ombudsman. And an ombudsman performs officially in their office and is not carrying out a personal duty. Accordingly, she was of the view that it compromises the independence and integrity of the office for the officer to be asked to take personal responsibility for actions that were carried out in an official capacity. And this had to do with the fact that the incumbent PP has had personal cost orders made against her by our court. Adverse cost orders should be borne by the respondent institution and not the public protector personally. And if criminal charges arise out of the same set of circumstances where a personal cost order has been granted, she said that it sounded to her like that may amount to victimization. She reminded the committee that an ombudsman is a single person who is constituted as a corporate soul and is being asked to shoulder the responsibility of an entire organization. And so personal costs in her view were a form of judicial harassment and were unacceptable. On the time limits for submitting complaints to the Office of the Public Protector, she said that this should not be read very narrowly, and this has to do with that 2-year time frame in the Act, because an ombudsman should have a lot of discretion. And she cited an example saying, for poor people who come from rural areas, they may not know that they can actually appeal. They may not have the money to actually reach the Office of the Ombudsman, and they may take more than 2 years to bring complaints. She said unlawful or retaliatory suspension is a form of administrative or judicial harassment. And the binding decision model makes the ombudsman amenable to review of their decisions by a court of law. And that would be because when decisions are binding, people would be more inclined to want to take that on review. The courts, she said, also seem to feel threatened by the judicial powers of the ombudsman, and there's always a temptation by any one of the 3 arms of government to trim down the powers of the ombudsman. And she said this is evidenced by matters in our own country and here in South Africa. And once the powers of ombudsman seem to overlap or to be shared by any one of the 3 branches, inevitably the institution of the ombudsman may have to be reined in by the arm which feels challenged. She said it's very important that during the course of investigation, an ombudsman has the complete cooperation of the respondent institutions, being the executive. The ombudsman is the only institution which the poor man can call upon. If a process in a particular country involved the refusal to call essential witnesses or relevant witnesses that are specifically mentioned in charges, thereby denying the accused person an opportunity to clear their names, she said this would not be in conformity with the fundamental principles of natural justice. And the person's right, firstly, to be properly represented, secondly, to properly defend themselves should be respected and upheld in any constitutional democracy. And then lastly, that it's an unintended consequence, as I mentioned earlier, that the binding model litigation costs would shoot up because people would be more likely to challenge decisions. However, with reference to our own office, members might recall that Ms. Sacconi said that she had gone through the experience of one of her reports being taken on review. She said that she must confess that we have actually raised our standards very high, because whatever evidence we get, we interrogate each and every piece of evidence thoroughly, because we know that when the report comes out, there's a possibility that it might be taken to court. So that's actually made us a little bit more cautious. It takes us a little bit longer now to issue a report because we have to really do our due diligence and really interrogate our cases so thoroughly. Chair, the next section of the aid memoir deals with intimidation, harassment, and victimization, referred to in paragraph 10 of charge 4. And I'm not going to read that charge out, but the reason that I've included it here is that These terms were not defined in the motions. I just thought it might be useful to give a brief explanation of what these concepts are. Harassment is defined, the dictionary definition is intimidation, bullying, threatening, or coercive behavior, including manner of speech, usually by a superior towards a subordinate, and sometimes by colleagues in an organization. In South Africa, it's dealt with in the Promotion of Equality and Prevention of Unfair Discrimination Act, which describes harassment as unwanted conduct in the workplace, which is persistent or serious and means, humiliates, or creates a hostile or intimidating environment, or is calculated to induce submission by actual or threatened adverse consequences. The Code of Good Practice on the prevention and elimination of harassment in the workplace, which is issued in terms of the Employment Equity Act, aims to eliminate all forms of harassment in the workplace. And that code recognizes various forms of harassment that may amount to unfair discrimination. So whereas previously only sexual harassment was dealt with in terms of the code now deals with harassment on many grounds. And I think we've got it in a footnote. Harassment is generally understood in terms of the code to be unwanted or unwelcome conduct which impairs dignity, creates a hostile or intimidating work environment for one or more employees, or is calculated to or has the effect of inducing submission by actual or threatened adverse consequences, and is related to one or more of the grounds in respect of which discrimination is prohibited, and the grounds of discrimination are captured in the footnote. Example of harassment according to the code include physical and sexual abuse, but also abuse of a psychological or emotional nature. In terms of section 4.4 of the code, the test to determine whether conduct constitutes harassment is assessed on an objective basis from the perspective of the person who alleges the harassment. The primary focus should be on the impact of the conduct on the person who alleges the conduct, with reference to the reasonable person. In other words, would a reasonable person in the position of the complainant view the conduct as harassment? Intimidation, Chair, the dictionary definition is the action of frightening or threatening someone, usually in order to persuade them to do something that you want them to do. And the code defines intimidation as intentional behavior that would cause a person of ordinary sensibilities to fear injury or harm. Victimization is defined in the dictionary as treating someone in an intentionally unfair way, especially because of their race, sex, beliefs, etc. The statutes regulating labor law do not deal directly with victimization. However, the Labor Relations Act indirectly deals with it, in terms of which certain unfair labor practices could amount to victimization. So, for example, unfair conduct by the employer relating to the promotion, demotion, probation, or training of an employee, or relating to the provision of benefits, the unfair suspension of an employee, or any other unfair disciplinary action short of dismissal, a failure or refusal by an employer to reinstate or re-employ a former employee in terms of any agreement, and an occupational detriment other than dismissal in contravention of the Protected Disclosures Act on account of the employee having made a protected disclosure as defined in. Chair, the last part of the aid memoir deals with the general issues that I alluded to when I started, and these are issues that are raised in the PP's Part A statement, which members are obviously familiar with and would have read. And whilst members are going to be deliberating on the charges in particular, I thought it's necessary to deal with these issues. The reason being that members must be certain that the process that they followed is fair. And these are issues where the PP has indicated that the process isn't fair or that point of unfairness. The way in which I've categorized it in terms of the headings is my own categorization, but where possible, underneath in the subpoints, I've taken it as directly as I can from the Part A statement. Nature and flaws of the Section 194 process. The PP alleged that the process does not represent a genuine impeachment process, It's a political process as emphasized by the Speaker, Chair, the President, and in the DA cooperated in court pleadings and not a conventional legal process. And the process is a politically motivated witch hunt. It's a vanity special project of the Democratic Alliance aimed at scoring political points, as being the first party to have caused a head of the Chapter 9 institution to face impeachment. It is a racially motivated campaign born out of the fear of real change which might actually benefit the poorest and most marginalized of society, who are mainly Black, at the expense of those who benefit from the untransformed economic status quo, who are in the main white and the backbone of the DA constituency. The DA has falsely labeled Adv Mkhwebane as spy and has made at least 5 separate attempts to remove her. The DA is abetted by the African National Congress. The ANC is motivated in turn by retaliation and revenge for the exposing of corruption and wrongdoing by powerful ANC leaders such as the president, and she refers by way of example to the CR17 matter in Phala and Minister Mkhwebane in relation to the SARS Road unit matter and what she called the fake retirement of his friend Mr. Pillay. There's an unholy alliance between the DA and the ANC, and these parties will use their majority power to remove her. The outcome is therefore predetermined. And in addition, the PC Justice at its meeting of 6th of March prejudged Adv Mkhwebane. The chairperson, who was a member of that committee, also made adverse remarks, such as here we have budgeted for incompetence. The process is illegal, inherently and irreparably unfair, biased, predetermined, and doomed. Adv Mkhwebane has participated under protest for the purposes of disproving the popular narrative that she was avoiding, was scared of the process. The inquiry is a charade. The proceedings are defective as a result of the following: the refusal to exclude charges in respect of which there was no prima facie findings, the repeated conduct of proceedings in her absence and in the absence of the legal team, the refusal of the chair and Mr. Milam to recuse themselves, the refusal to call the President, Ms. Mazzoni, and Minister Mkhwebane as witnesses, and the refusal to grant Adv Mkhwebane sufficient time to prepare her evidence. On matters of suspension, she said her suspension is not bona fide, it's vengeful, retaliatory, and an illegal act by the current president owing to the multiple investigations that she was seized with, including CR17 and Phala, to name a few. Those were the only 2 that are named in the OJ. And the suspension is the real reason why we are here today. In terms of witnesses, she noted that Mr. Mkhwebane was a helpful, cooperative, and truthful witness, but Prof. Madansela was a hostile, uncooperative, and untruthful witness. The committee refused to call key witnesses requested by her, and the committee refused to recall Mr. van Rottenberg, Ms. Valoy, and Mr. Philip. On the charges, she said the charges had been concocted by Ms. Mazzoni. Any objective, fair, and reasonable analysis will lead to a conclusion of not guilty. And Chair, I don't like the use of that language. That language is not contained in the motion about guilty or not guilty. It's whether the committee has found that there's misconduct and incompetence, even though we refer to charges. Witnesses called by evidence leaders have effectively exonerated Adv Mkhwebane of any impeachable wrongdoing in respect of every charge, and no fair court will uphold a contrary finding. The impeachment effort is therefore doomed to fail if subjected to fair judicial scrutiny. The IP recommended an inquiry in respect of matters where they found prima facie evidence only. However, the committee illegally extended the scope by, for example, considering the Pillay pension matter in the HR charge. The committee failed to deal with the motion, therefore, as filtered. It said the removal rules were crafted as a copy-paste job by the DA, and the rules were targeted at her, and this is evidenced by the fact that it provided for a mummified lawyer to sit in the inquiry. There were also some what she called glaring absurdities. She points out that her 7-year term ends in mid-October 2023, and by the time she had drafted her statement, she had said that was in 6 months' time, but of course it's far closer now. The inquiry is estimated to cost the taxpayer approximately 1 million per day. And Chair, this amount gets bandied about, but I think it came from a statement made by a member very early on in the process. But nonetheless, the cost of instability to the office of the PPSA is incalculable. Adv Mkhwebane has made several attempts through the courts to stop the continuation and the commencement of this illegal process. But these efforts to stop this futile and costly exercise have always been opposed by the Speaker, the Chairperson, and the DA. Chair, a lot of these issues that were raised have been considered by the committee. Some of them we've responded to in writing. Some of it was raised in the first refusal application. So, for example, issues, if I recall correctly, on the summoning of the president and so on. So, for purposes of drafting the report, we will obviously place a reliance on what the decision of the committee was in respect of some of this and what's contained in correspondence in respect thereof. Chair, in conclusion, in determining the veracity of the charges, the committee must have due regard to the evidence before it, which includes witness statements, court records, oral evidence, the statements of the PP, evidence before the independent panel, and evidence tendered as part of the report. The summation that's been done by the evidence leaders merely seek to summarize the evidence before the committee. But it's important to remind members that the role of the evidence leaders are not to make findings on behalf of the committee. The summation is based on relevant evidence, and the evidence leaders have therefore not summarized things that may be irrelevant to considering the merits or veracity of the charges. So if I give by way of example, you'll see that the summation doesn't deal with evidence from Mr. Nyatela, because that wasn't directly related to any charge. What the evidence leaders also haven't done, Chair, is to consider the credibility of any witness, where they relied on evidence either because evidence has been corroborated or because there was documentary evidence. It's for members to decide whether the testimony of any witness was not credible and therefore calls not to be considered. However, I am reminding members that the evidence leaders have tried to show where there is evidence to support the evidence, notwithstanding where there may be a credibility issue. But of course, that's for the committee to decide. Again, the committee can only decide if there's been misconduct or incompetence by judging what the standards are against the evidence, and in that way reach a rational conclusion. And importantly, the committee must be satisfied the process has met the threshold of fairness as required in the removal rules. In this regard, the committee is reminded of all the correspondence, and I think one of my colleagues from legal services in the first 2 or 3 weeks of the committee referred to as a carnival of correspondence, and he thought that was a carnival at the time. I'm not quite sure what to call it, but there's a lot of correspondence that has been tabled. A lot of it deals with objections and so on. Members would have obviously read it and are aware of it, and they need to apply their mind, because before moving to the issue of whether there are reasons that support or don't support the removal, members must be satisfied that the process has been fair. Also, Chair, I just want to mention that Adv Mkhwebane's statement was obviously drafted some time ago, and since then there's been further objections to parts of the process and further issues raised that wouldn't have been captured therein. She has captured those things though in the correspondence, and it includes, for example, this second refusal application, and it includes the fact that she alleges that the committee has proceeded despite her not having legal representation. So the committee can consider that further. Chair, I'm sorry that took a little bit longer than I expected, but I hope that helps members as we move to the next part, which what we've done there, Chair, is to make things easier to set out these questions. We have done those definitions of incompetence and misconduct to try and assist the committee, but because the motion deals with subject matters like sex and theatre, they don't necessarily follow the motion in order. But hopefully that will assist members, and those questions will also reference where in the summation the summary of the evidence can be found. Thank you, Chair.